Good morning. Thank you for being here today. We will hear the cases in the order that they appear on the docket. A couple of things to remember. One is that these are live streamed, so what you say goes out into the internet, and wherever that goes, what you say goes. So you might want to remember that. Secondly, up for the appellants, when you come up, introduce yourself. Please let us know if you wish to reserve time for rebuttal, up to 5 minutes. If there are no announcements or introductions, seeing nothing, let's call the first case, please.
Mary Elizabeth Brindle story versus Charles Edward Brindle.
Morning, I'm Rebecca Bird for Elizabeth
Hi.
I would like to reserve 3 minutes for rebuttal.
2,
3.
3. Thank you.
Your Honors, this case is less a case of an abuse of discretion than it is a case of legal error. The court rewrote the party's child support order. It redefined uninsured medical expenses contrary to the guidelines, and it conditioned medical decision-making authority on a parent's financial exposure, a factor not considered in the statute. Each error independently warrants reversal. Together, they fundamentally undermine the children's medical stability and financial protection. The first issue I want to address is the medical decision-making. In the court's ruling about the medical decision-making, the court expressly held that granting mother sole medical decision-making would create a moral hazard unless father's financial exposure was constrained, and therefore refused to modify the decision-making authority from joint to sole. The Tennessee law is explicit. Under 366407, the primary question is, can the parties make the decisions jointly? Financial exposure is not a statutory factor. It is not included in the statute. The court never made a finding that the parties could cooperate, only that fathers should be protected financially. Treating medical decision as a financial risk problem is not considered in the statutes, and conditioning sole authority on limiting father's reimbursement is
Wouldn't
not.
it be fair to say here that some of the tension between the parents was a result of their differing understanding of what the reimbursement requirement was under the agreed parenting plan?
I would disagree with that,
And why is that?
because the record was replete that there wasn't that the issue on whether or not it was a reimbursable medical expense did not even come up until trial.
I thought your client was having difficulty collecting on some of these expenses.
She was having difficulty collecting, and that
I mean,
was
that suggests to me that there might be some problems.
And I would understand that suggestion, Your Honor, but for the record showing that father really made none of his reimbursable medical expense cost until the litigation was pending, until after he filed his petition, and then really only in the months leading up to the trial. So it wasn't an issue of whether or not it was a reimbursable medical expense. It was an issue of ongoing father's delays in making decisions, in responding to mother, and in failing to reimburse mother.
Now, I thought under the system that the plan contemplated, mother would make the initial choice about non-emergent medical care, and then a 7-day period would elapse, and if no response from father, that would be the decision. Is that not the case?
That was what her right was under the order, Your Honor, but that didn't happen in practice. Because what would happen in actual practice, as is shown in the record, is that mother would send the information to father immediately, would ask for responses, would not get a response, but when she would act under that authority, then father would say, no, I'm not going to pay for it, I never agreed to it.
Well, it seems like to me then that the response would necessarily be for your client to go into court and hold the father in contempt for not paying the legitimate expense incurred, right?
And I would agree, except that this is such a multi-time action that requiring mother to come into court on contempt on the multiple occasions would just further deplete her resources.
But at one time, I mean, this expense was what, over $30,000, is that correct?
Correct.
I mean, certainly that seems a significant amount, certainly worthy seeking intervention of the court, would it not?
It would. I would agree that it would be great if we had a contempt action, or if mother had found father in contempt. Mother chose to seek reimbursement as opposed to trying to put father in jail, as opposed to trying to seek further punishment against father. And each one of the record is so, there's so many instances of failure to reimburse that it just becomes overwhelming.
But your position, bottom line, is you feel like both parties had a clear understanding of what the plan required.
Yes.
Okay.
And I do feel also that in Ms. Steyer's testimony, that she makes that clear as well, because the children's medical decisions were an issue as well as Mr. Brindle's parenting decisions were the primary issues that would come up in the sessions with Ms. Steyer. And she talks in her deposition about how they discussed these decisions and worked to coming to a joint decision. So I don't at any time think that it was a question of whether or not it was reimbursable until we came to trial.
Counsel, with regard to the uninsured medical expenses, we're still operating under the original Washington order, right? There's no modification of what uninsured medical expenses are, or was there an attempt to modify that?
There was no attempt and there was no request to modify that.
Well, I'm struggling a little bit. So each parent is responsible for a share of the uninsured medical expenses as ordered below. Uninsured medical expenses include copays, premiums, and deductible expenses. And isn't that second sentence essentially definitional of what is an uninsured medical expense?
The order goes on to refer to a specific Washington statute as explanation for the definition of reimbursable medical expenses. The Washington statute is a broader statute similar to the Tennessee guidelines. And I think that's RCW 2619.080.
And it's used as a footnote on premiums. So how are you incorporating, where's the broader understanding? I mean, in a vacuum, I understand your contention in terms of uninsured medical expenses, but how are you getting to a broader understanding, and why does the Tennessee definition particularly matter here if we're not modifying in terms of uninsured medical expenses?
Well, first, the court did modify by putting in a specific definition. And secondly, the Washington statute, I do think, controlled on that parenting plan at the time of its issuance and agreement. In this case, the record was replete with the parties' inability to work together to make any kind of decision in a timely manner, and this impacted the children's medical health. And so mother is requesting that they...
Was there any medical proof on that point? I know that the brief mentions the severe medical conditions for all three children, but was there a medical expert or any medical testimony that came in to say how this was adversely impacting the children?
No, there was no medical expert that talked about the outcomes. Mother testified about the children missing school. Mother testified, and that was undisputed, on them missing school as a result of coming back from father's visits when the medical care was not adhered to. Mother testified about the delays in certain treatments for the children by waiting for responses from father. So we do only have mother's testimony, which is undisputed on that. But as far as a medical practitioner's testimony.
So you're saying there's no factual dispute that the children were suffering because of father's failure to adhere to their medical restrictions.
Correct.
Okay.
The second issue, along with this, is the deviation and the court's removal of the deviation. The court found in reviewing...
Counsel, I want to make sure I understand on the child support portion of it, you are not challenging the court's adjustment of the child support calculation under the Tennessee guidelines, because it ended up increasing, I guess, father support obligation. There's no challenge to that.
There's no challenge to the base child support amount, no.
It's just the deviation.
The deviation, yes. And our challenge to the removal of the deviation is that the conditions that existed at the time that the deviation was entered remain in existence at the time of trial. And the court acknowledged this. The court acknowledged that at the time of the divorce, the children had these severe medical conditions, all three of the children did, that all these medical conditions continue and remain to today. The court acknowledged the expensive medical care that these children required, and so the basis for the deviation never changed. The mother testified that in addition to these unreimbursed medical expenses, these children with their medical care have other expenses that are not even a part of what father reimburses. These additional expenses are part of the reasoning behind why there was a deviation and upward deviation. And that includes the...
So what do we know precisely, though, about the reasoning behind, because that was an agreement, right? There was no Washington court finding a deviation is justified because of X, Y, or Z. The parties just agreed on that. So what do we take from this record about the purpose of the original agreed deviation?
Well, there is a court finding in the order, because the court finding was that the parties agreed to the deviation based on the children's special medical needs. That's very similar to what we write in our parenting plans when the parties agree to a deviation in a child support order. It's simply stating that it is because of whatever condition, it could be the parents' times or incomes, the medical needs, or the transportation, whatever the issue is. But when entering a parenting plan with the child support provision where the parties agree, then they make the statement on what it's based. They don't go through all of the factual findings that a court would at the conclusion of a trial. So as far as the Washington order, there is a legal finding on why the deviation was set in place, and that finding continues to remain in existence today. The court's emphasis on that there wasn't a specific trier of fact, that this was an agreement as opposed to being through a trial setting a deviation, is no different than what we have in Tennessee. When we have parenting plans and we enter support orders and they're by agreement and the court approves it, the court is required to review that to ensure that it complies with the guidelines and then make a decision on whether it approves it or not. But it doesn't require the court going through and making a specific detailed findings of fact when the parties enter an agreement. I think my time is up for the rebuttal.
Yes, it is. Thank you.
May it please the court. Good morning, my name is Alyssa Castronovo from the Nashville Bar, and I, along with my co-counsel, Mr. Andrew Goldstein, represent the appellee and father in this matter, Mr. Charles Brindle. This appeal is largely an attempt to reweigh evidence and revisit discretionary best interest calls. The trial court clarified ambiguity in the original parenting plan order. It applied the Tennessee child support guidelines appropriately, and it fashioned practical relief for these parties, none of which should be found to be reversible error. There are numerous issues before the court today, but they boil down mainly to three main issues: whether the parenting plan should have been modified, whether the child support issues were addressed appropriately, and whether attorney's fees should have been awarded. Turning to the first issue regarding the parenting plan, Appellant asks to reverse the refusal to allow appellant's sole decision-making for non-emergency medical and extracurricular decisions, and the refusal to modify the parenting plan in place. Best interest determinations and parenting plan allocations are fact-intensive and reviewed with strong deference. When reviewing the trial court's decision to maintain the provisions regarding parenting time and decision-making, it should be reviewed with that abuse of discretion standard. Regarding the healthcare decision-making authority specifically, the trial court solved the actual problem, which was the ambiguity driving the conflict. The court did not rewrite father's child support obligation. It simply clarified what uninsured medical expenses were to stop this conflict over collateral, non-covered items. And the joint decision-making was a reasonable best interest safeguard given the evidence. Keeping joint decision-making assures objectivity given disputed non-emergency
Well,
choices.
should we be concerned here that father only seems to engage in the non-emergency healthcare decision-making when it comes time to repay his portion of the incurred expense? I mean, you know, I would probably be more sympathetic to the father's position here if I saw at some point he received notice from mother. Within the 7-day period, he alerted mother, no, you're not going to, I disagree with this approach. Let's take our mediation or conflict resolution procedure in place here to try to resolve the decision. He seems to wait until the bill's due.
So while it may appear that way, there were instances in the record there that the parties did engage in thorough communications regarding the medical health decisions that mother was attempting to make. For instance, with the biofeedback therapy, mother was proposing a very experimental treatment on a minor child. Father had the 7-day notice period. He stated, I need more time. This isn't sufficient time. This is a highly experimental treatment. I need more time to review whether this is in our child's best interest. He ultimately felt pressured by mother and Ms. Dyer to acquiesce to mother's desire to proceed with this treatment. But that shows that the parties are able to talk through things and come to an agreement.
So were there other instances beside this experimental treatment where father engaged in that way within the 7-day period? And is that in the record?
It's my understanding that the parties both testified regarding this issue. He did testify as to, okay, can we look for other options for the children's mental health? Mother stated no. There was no further discussion had between the parties, and ultimately he deferred to Ms. Dyer's recommendation that, okay, keeping them within these current therapy modalities is in the children's best interest.
I'm glad you mentioned Ms. Dyer. Her role confuses me a little bit. It seems like the intention was for her to be some sort of therapist, but instead she ended up being a mediator. Is that what happened to try to resolve conflicts on decision-making? Is that what occurred?
So initially, Ms. Dyer was put in effect to help the parties co-parent and act as a therapist per se to allow the parties to co-parent better. However, this turned into mother utilizing Ms. Dyer repeatedly, and the record is clear that mother, instead of the parenting plan, which initially stated that it was to be Ms. Dyer to suggest additional therapy sessions as needed, instead the record shows that mother would go to Ms. Dyer, request that Ms. Dyer aid mother in browbeating father into conforming to whatever mother believed was best. And that is what happened, and that is why father was so adamant that this should not continue. It was far beyond what the initial parenting plan had proposed, and Ms. Dyer testified that it was far beyond even her most contentious co-parenting parents previously generally only had 10 sessions with Ms. Dyer, whereas these parties had nearly 40. Moreover, father would disagree with the contention that mother was able to sufficiently argue that the children's health was impeded during father's care. Mother attempted to lay that testimony at trial, and father properly objected to the lack of foundation for that issue, and that objection was sustained. There was no evidence in the record showing that father was impeding the health of these children. In fact, the evidence showed that father cared very deeply for his children. Both parents recognized that the parties had substantial health issues, and they were trying to work through these to support their children as best as they could, so much so that father was having to forego parenting time to help support the medical needs of his children because he could simply not afford it. However, the record shows that mother's clear history of requesting highly costly and atypical medical treatments for the minor children would indeed create the moral hazard that the trial court addressed. It wasn't pulled out of thin air. It was substantiated from the proof that was put on at trial. Turning to whether the parenting schedule should be modified, it was mother's burden of proof to show that there had been a material change in circumstances warranting her proposed modification of the parenting plan, and that the proposed modification was to be in the best interest of the minor children. Trial court simply found that mother did not meet her burden. The schedule that the parties agreed upon during their divorce, which was only 3 years prior to the trial here, supported a stable relationship with father. And father demonstrated at trial a strong desire to continue to exercise his full parenting time, and credibly testified that had it not been for these extreme reimbursement expenses that were requested by mother, that he would have exercised all of his time. Time and time again, he was forced to choose between medically providing for his children or spending time with them, which is an impossible decision that a parent shouldn't have to make, but that father was handling as best as he could. The court tried to mitigate that harm by clarifying the language in the parenting plan to permit father time with his kids. Turning to the child support issues at play here, starting with the upward deviations removal. Under the Tennessee child support guidelines, deviations may be eliminated if circumstances supporting the deviation cease to exist. The underlying reason for the deviation was that the parties agreed to it. The parties were no longer in agreement that the deviation was warranted, and thus the court properly found that it should be removed. The trial court found no evidence beyond that initial agreement. The trial court also identified that a deviation was no longer warranted because father's pro rata uninsured reimbursement of expenses would continue. It also found that both parties' incomes had substantially increased since the time of the parties' initial divorce. This is a classic discretionary recalculation. When the justification no longer exists, the rules clearly allow elimination of the deviation.
And your client is not, beyond the upward deviation or elimination, your client is not challenging the court's decision to recalculate the base support amount under the Tennessee guidelines.
Correct. He understood that this was an equitable relief that the trial court imposed, given that they were removing that upward deviation, so we are not challenging that. Turning next to the issue regarding the interpretation of the uninsured medical expenses. The Tennessee child support guidelines define uninsured medical expenses to include, but not necessarily be limited to, co-pays, deductibles, and reasonably necessary costs, including counseling, etc. And the trial court may order only reasonable uninsured medical expenses be divided. The trial court here defined uninsured medical expenses as costs payable to providers for recognized, reasonable, and customary therapeutic interactions not fully paid due to cost sharing. This clarified definition is consistent with the guidelines' reasonably necessary limitation and the trial court's authority to restrict it to reasonably uninsured expenses. The trial court's narrow objective standard prevents these endless disputes that the parties were having over collateral, travel, lodging, experimental modalities, and protects the children's financial stability. Turning next to the arrearage alleged for the reimbursements.
Well, before you get to that point, which I am interested in, your position is, though, contrary to mother's position, is that the father thought there was a misunderstanding about what was required for reimbursement.
Yes. And the record was clear that despite the language of the Washington plan that limited the proper reimbursements, mother would then take the children to receive care in Ohio. And instead of there being a sufficient reason versus receiving care locally, mother's only reason was, well, this is where the kids have gone over the last few years. I trust the care there. That's where we're going, instead of local providers here, which
Well, when the original plan was agreed to, though, weren't the children going to Ohio?
No, and the record will show that there was about a 3-year period where the children were not going and receiving care in Ohio.
So at the time the parties agreed to the upward deviation, Cincinnati wasn't in the,
Correct, because the
Okay.
parties were located at the time in Washington, and traveling to Ohio from Washington would be a much more substantial
I
drive.
thought the parties had already moved to Tennessee and Indiana at the time the agreement was entered into.
Yes, but I believe the children were receiving generally a yearly checkup, and I don't believe the record is clear as to whether that had gone back into effect prior to the divorce.
Okay.
So
So the reimbursement is where I interrupted you.
Yeah.
There's a delay there.
Yes. So with the reimbursements issued, both parties agreed that at the time of trial, father was current on his child support, despite the substantial upwards deviation that had incurred. The only issue left in dispute was whether or not father had sufficiently reimbursed mother for the medical expenses. Out of the over $32,000 that mother had requested in a 3-year time span, mother alleges that at the time of trial, he was only $6,192.17 short. However, as the court has already recognized, there was no contempt allegations because the language was unclear as to could you hold father in contempt for his failure to pay some of these requested reimbursements when mother herself admitted on the stand that those requested reimbursements were not all reimbursable expenses. And the trial court thoroughly heard testimony from both parties regarding these various items in dispute, seeing that mother was taking the children to Ohio, taking the children to Iowa, taking the children to chiropractic care that was disputed, making all of these choices, and then saying, well, I took the kids to Iowa, and I had to get them a hotel, and I had to pay for gas, and none of those expenses were reimbursable under the parenting plan. The court looked at that. The court looked at father's disputed charges. There was sufficient testimony based on all of that, and father credibly testified that he thoroughly reviewed all of the invoices received by mother and found that he had indeed reimbursed her for all reimbursable expenses under the plan. And the court found his testimony to be credible and found that it was mother's burden of proof to prove otherwise, and she failed to do so, instead relying upon hundreds of pages of email exchanges between the parties for the court to try to dig through to corroborate her statements. Regarding the reimbursement timeframes given by the court gave father a very equitable plan of, okay, mother wants a clear timeline for when these payments are going to be made. The court was within its discretion to list out a clear timeline, giving him 12 months to reimburse those payments. Given that I'm almost out of time, unless the court has further questions, we would respectfully ask that the trial court's judgment be affirmed. Thank you.
Thank you.
If I may follow up on some of the statements made. In talking about the definition of the unreimbursed medical expenses, you raised the question on whether there'd been a modification of the Washington's parenting plan regarding unreimbursed medical expenses. First of all, the Washington parenting plan references that the amounts entered are in compliance with the Washington child support guidelines. So it continues to reference the statute under which I was referring to earlier about the out-of-pocket expenses. Secondly, in the Tennessee order, the trial court judge modified or set child support under Tennessee child support guidelines and repeatedly referenced Tennessee child support guidelines and under Tennessee child support guidelines. Yet the court changed the very definition of what unreimbursed expenses are. So the court made a modification, placed it under the Tennessee child support guidelines, but then took on the additional step of seeking to usurp what the guidelines language is regarding unreimbursed medical expenses. We'd submit that that's reversible error. In regard to the question about whether the children were going to Cincinnati, the testimony was that the children had been attending Cincinnati and had their doctors there my recollection is around 2011, something like that. So for years, and in fact, the testimony, undisputed testimony, was that the parties at one time even lived in New Mexico, and the children continued traveling to Cincinnati for their treatment and would go there for their treatment. So the Cincinnati doctor, in fact, all of the practitioners that mother used were the same practitioners that had been used prior to the divorce and continued to be used after the divorce. So there wasn't any change in what the ongoing care was.
So while they were living in Washington State, then the children were still going to Cincinnati?
Still going to Cincinnati, even in New Mexico. Wherever the parents lived, they continued their connections with the Cincinnati Children's Hospital. This is, I very rarely have clients who have kept such detailed records as Ms. Story did. Her monthly reporting that she did to father is something that should be commended, because not only would she provide him with each and every invoice, she also laid out spreadsheets showing what he had paid, where it was applied, even if he reimbursed something from the past. And that was not disputed. She also testified at length about all the care that she did to try to limit what those expenses were. Father admitted that at no time since the divorce had he ever done any research on who the children's medical care should be or what medical help they should be. No research on how to limit the cost. He just says you need to limit it, you need to do this, but he had no options. Mother was the one who had taken on all of that responsibility, all of the time and effort of doing that, and saved both parties considerable amount of money, even using over-the-counter drugs when it would replace what a prescription cost was and substantially limit what the party's exposure was. So the out-of-pocket cost that remained due, when you look at that spreadsheet and you see where mother itemized each and every payment made by father and when it was made, you will see that that cost was as low as it was because father intentionally waited until right before trial to start making significant payments on what his share was to lower his liability on that. It is not a fact of father trying to pick and choose, and he never said which ones he paid and which ones he didn't.
Your time is up, so thank you very much.
Thank you.
Thank you. Would you call the next case, please?
John Tyler Cobb versus City of Columbia, Tennessee.